Where we left off last time was our discussion of 3 stages of negotiation that will take place regardless of whether or not there is a problem-solving negotiation or whether or not we're talking about a position bargaining negotiation that's going on. That you really have to plan for 3 things. First, we need to plan for the information that is going to be gotten and blocked, and we talked a good deal about that, about how that goes on. And then you remember we also talked about, or signaled that we would talk some more about the exchange phase. And finally, we also talked about persuasion as a piece of what it is that's going on, and you have to prepare for all 3. And what I'd like to do is to try to integrate problem solving and position bargaining into one integrated model, saying if you plan for these 3 different stages in these different steps, you will be able to negotiate and control your negotiation whether or not it's a problem solver you're facing or whether or not you're dealing with a position bargainer. So let's talk together about what happens in a negotiation and what you should plan for, and think about it chronologically, what typically happens first, second, third, fourth, and on through. So in thinking about it, there are approximately 10 steps to a negotiation. You're obviously already planning in your strategy what your style is going to be. And so what you need to do is your strategy is going to say, I want to be a position bargainer or problem solver. I'm going to be a competitive bargainer in my style, or I'm going to be a cooperative problem solver in my style. So I'm going to plan for my strategy and my style. Those are 2 of the things I have to prepare for. Number 3, those questions that I'm going to try to get answered during the negotiation. I do as much as I can to get the information before I go in, but your planning should always include some questions to ask the other side about what they think about the case, about what their strengths in the case are, about how they're dealing with the weaknesses. That information is very important for your ability to try to get how they see the case, how they evaluate the case, and to see whether you're missing something which could potentially affect dramatically how the case ought to be heard or is going to be heard. Are they going to be able to produce an expert witness on a key fact in the case? Who is the expert witness? Do you have that information? These are questions you need to ask. If you're negotiating over the purchase of something, do they have any other buyers? Are you it? If they don't sell it to you, are they really out of luck for a long time, and how does that affect supply and demand? And so information that you need to ask in order to get an idea of what the market is, what's affecting the market, how that affects the value of the case is obviously key, and you should plan for that. I even go so far as to suggest to you that in your planning, you write out the questions ahead of time. We'll come back to this in just a minute. There are ethical issues here that you push the lawyer on when you ask them tough questions. And so what you want to do is you want to make sure that you plan very concretely for what information you're going to need. What insurance policies are out there in a classic litigation context? What kinds of policies? Tell me all the policies that apply. Do you have authority under all of the policies? What are the sources of funds is going to be crucial to information you need to get to know what is out there, and to find out whether there is potential conflicts of interest that exist that the lawyer is potentially representing as you go forward. So information that you get, you've got to write those questions out and be prepared to ask questions about that. Obviously, we've talked about this some before, but you may be preparing to block questions that are asked of you. And we'll see that you might ask a question. You might say that you are not ready to answer that question right now. It might be that you don't have authority to answer it right now. It may be that you're still trying to find out what's going on and you don't have an answer to those questions. But you should be prepared to decide what you're going to reveal and how you're going to reveal it. And you've got to ask yourself whether or not you want to prepare a block in a particular situation. Now, when you're talking about blocking, obviously one of the blocks that we've got to talk about is whether or not there can be a misrepresentation. And first of all, let's describe what the dilemma really is here. If you represent a client and that client has given you authority to settle, then that's a fact that is out there. Whether the client has given you authority to settle, and presumably Model Rule 1.2a tells us that for lawyers who are negotiating on behalf of a client, they are to abide by the decisions that are made by the client concerning the objectives of the representation. And by the way, they also shall consult with the client as to the means by which they are to be pursued. And so if you're going to play hardball or if you're going to be conciliatory, you should certainly consult with the client about some of the techniques that you're using if you feel like they may push you up against some claims that you're operating outside the parameters of your client authority. In any event, if we assume then that the client has had a consultation with you about the value of the case and you have consulted with them, presumably they've given you authority and presumably they've given you some specific authority. So the question then is, what can you say about that authority? Well, of course, as a lawyer representing a client, your position is, I can't reveal confidences of my client. If I get asked the question, well, do you have any room to move? Or, is there anything that you can give me in this case about what the case is worth? Is there anything more that you can give me and concede? Obviously, potentially, revealing that would be revealing a confidence. But then again, the client, of course, is arming you with information to try to persuade the other side about the case. And so we have a basic conflict in the ethics rules between confidences and what else we're going to see in the rules. And that is that we're told as lawyers in representing a client that a lawyer shall not falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness is not prohibited by law. All right, but what does that do in a negotiation? Does that mean that if we overstate a client's position or we overstate their bottom line or understate their bottom line in order to generate a settlement that in fact we have made a misrepresentation? The fairness to opposing party counsel prohibition on testifying falsely seems to be directed at folks who are in some kind of an adversarial proceeding. Well, Model Rule 4.1 though goes on, and it says that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a person when disclosure is necessary to avoid assisting in a criminal or fraudulent act by a client. Folks, what this means is that, first of all, if a question is asked directly to you about what is a material fact in the case, you may not lie about it. As a lawyer, you risk your own professional responsibility obligations if you make a misstatement. And you might just think of it this way. If the client was there and the client was asked that question, the client couldn't lie, you can't lie about that statement. Now, in response to a question then, does that trigger an obligation to disclose the truth, or can you block in some way the answer to the question? Well, you can certainly block. There still is no false statement. And there isn't any failure to disclose to a third party who is your adversary. There's not an affirmative obligation to make the disclosure, so that the block then does not constitute a misrepresentation. But again, the question then is, what if they ask you, can you move? Do you have authority to move? Can you give us anything more? Or at your bottom line, can you say no? Would that be a false statement of material fact? Well, it depends on what we mean by the word material fact. The comments to the model rules provide that whether a particular statement should be regarded as one of fact can depend on the circumstances. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. So what are these? Estimates of price or value. So let's be clear about that. If we're talking about the estimate of price or value about the worth of something, about even the value of the lawsuit, what you think that the lawsuit is worth, you're making a representation of the estimate of what you think the case is going to be worth at trial, and if the client actually values this case lower than you, there is no material misrepresentation for you to overstate the value of that case, because it's not a material fact. Estimates of price or value are in the eye of the beholder. We don't take them as factual statements, and so those are not heard to be statements of fact. But perhaps more important for our topic, on the subject of the transaction and a party's intentions as to an acceptable settlement or a claim are in this category. All right, your client's intentions with regard to settlement. Here's the catch. If you've had a counseling session and the client has given you authority to settle, then what happens is you've got information that presumably puts the lawyer under pressure when the question is asked, can you move any on this settlement negotiation? You may have direction from the client that yes, you can. I don't want you to leave there until you give us the bottom line. I want you to offer the bottom line before we go. Can you then say, in the answer to the question, can you move? No, I can't. I don't have authority to settle. Well, the rules read that intentions as to an acceptable settlement are heard not to be factual, and therefore it looks like you're freed up just to simply lie. But let me suggest to you that before you go there, you also take a pragmatic look at the effect of lying about that. First of all, there is a fair amount of leakage that's going to occur if they then get up and start to leave and you say, well, wait, let's talk some more. So it gets you into a bind right away if you make the statement no, but what you have is now a cover that you've got to make in order to be able to give you an excuse. Sometimes lawyers actually go through a fair amount of planning and strategy to try to set it up such that they have their client give them just limited settlement authority in the first negotiation that forces them to say, I don't have any more authority to settle than X today. I'm going to have to go back to my client. And that way what they do is they're able to stand firm and make sure that they get consultation from the client before they go forward. What that does is allow them to say, yes, I have settlement authority today, but maybe not have the kind of bottom line settlement authority that we are anticipating they have. This would allow them then to say no and draw a line clearly, but perhaps actually have some more room to work on. And you need to be able to realize that that might be something that's been staged here in some regard. In addition, I'd like to suggest to you that if you have been given authority to go further, you may want to try, in fact, thinking carefully about saying, look, I will not recommend a lower amount unless I've got a better reason to go forward. To say something that says, takes it away from the question of do you have authority to settle as to whether or not you are recommending it or going to recommend it. And whether your position as an advocate then changes the nature of this question and blocks the question so that you do not give any more authority away. Your opponent, who is pretty savvy, will hear that you have not answered the question. Do you have authority to settle? If you say, I'm not going to recommend a higher settlement amount, the opponent likely could say, yes, you've got more authority today, and you could go further. And so there is some leakage that goes on there. Or you could say, I'm not ready to talk about settlement bottom lines unless you're going to exchange yours with me. That's another option that you sometimes hear lawyers do. But again, that also leaks that you probably have authority because you wouldn't be stating it that way. If you don't have authority, you just say no. In any event, what is clear is that when you're asked about your bottom line, what's at stake is that you should and can, as to the intentions of the client's acceptable settlements, those are not factual statements. Not you should and can then lie. That's a strategic matter, and I would suggest you first try to block before you go to any kind of a misrepresentation. The reason because the misrepresentation affects you, your credibility, and it'll affect your effectiveness in the negotiation going forward. And my own judgment for you is, as opposed to lying about it, that your position should instead say, I'm not ready to talk bottom lines. I won't recommend your settlement offer as a way of getting around this ethical dilemma. Now, back to our 10-step model. You see the importance then of your strategy and style tactics choices, the information you're going to get, and then planning these blocks. Trying to decide, what am I going to do if I get asked hard questions on facts? You can't make misrepresentations. You can't make misrepresentations of material facts. You do have some more room with regard to the intentions of the client's settlement. So let's talk for a few minutes about planning in your opening offer. Now remember, what we're talking when we're talking about your opening offer is, we're talking about something that is related to then persuasion. You're going to try to persuade your opponent about why you think this case is worth a lot of money, or why you think the case is worth a little bit of money. And it's important to think about how you prepare to do that. You know, lawyers should prepare your persuasion statements in a negotiation very much like you prepare a persuasion statement in front of a jury. You're going to look at it and you're going to make arguments, you're going to make appeals. To your opponent, you try to persuade them perhaps sometimes by threatening them as to what's going to happen at trial if you don't do what you say, or what the costs are going to be if in fact they don't go ahead and settle this case. You may make promises to persuade them. If you promise to do this, I will promise to you that we will do these things in exchange for what's going on. And so we persuade folks in these 4 ways. In the context of a classic negotiation, your preparation of your persuasion should be detailed. It should have specificity to it. Why do you think you're going to win? And what amount? And why? What's the probability analysis that's behind that? Have you done any focus group work to give you some authority for the value? Have you had an appraiser look at it and appraise it? Have you got some offer of proof to help people see why the value is what you say it is? Is your persuasion also often what's called multidimensional? Does it appeal not only to the law, but does it also appeal to fairness? Does it appeal to the general facts in the case that strike people in a common sense way that it ought to be the way you say it is? When you're talking about the negotiation of an item, you're making statements about its usefulness and perhaps the multi-dimensional nature of the usefulness of the product to persuade them that they need it or that they should do it. Note here that when you're negotiating and you're negotiating with an opponent, what you want to do is you want to show some ability to be balanced. Balanced persuasion is better than extreme persuasion, because if you get out there too far on the extreme, if you are an adversarial competitive negotiator, people resist it simply because it can't be that clear. It can't be that simple. And obviously, you're overstating the case when you make it that strongly. And so an ability to show that you see it or view it objectively is an important part of your persuasion statement. Some folks argue that your opening offer should contain a concession of some sort, so that you're preparing for something that you show that shows a balance in the approach that you're taking. Your persuasion should be focused. It should be directly focused on what the problem is, and not a too broad statement, a too grandiose statement, which does not deal with the matter that's on the table, typically. And then finally, it must be appropriately emotional. If you're disconnected from it, if you don't have any passion, we don't believe it. And so the persuasion you've got to pay attention to, again, just like you would in front of a jury, whether or not you're communicating about it, some kind of principle or passion about what it is that you're doing. And preparing then a mini opening statement, 2 or 3 paragraph opening statement about what your strongest facts are in the case is crucial to negotiation. It's not that you're preparing it to force somebody to take your version of the facts. You're preparing it to change their mindset so that they start to move more towards you in the negotiation. And I would suggest to you that when you're lawyer negotiating, that you use BATNA. What is the best alternative to a negotiated agreement? And in Hewitt versus Gonzalez, that's going to include an analysis of the law. Now here is an interesting fact. When you have social science folks look at lawyers conducting negotiations, it's remarkable how few negotiations contain arguments about the law. It's as if lawyers have decided that the legal arguments both parties can make and they're a waste of time. But I would suggest to you that the more prepared you are on the law, that you show what the jury instruction is going to be, why there is a real problem with the fiduciary duty case on behalf of Gonzalez against Hewitt, that there isn't an obligation of a partner to be able to put further financial risk for the partnership as a part of fiduciary duty. The more persuasive you can make that argument, obviously, the better you're going to be. And your ability to argue under the law whether something is a factual issue or a legal issue, and whether you're going to survive summary judgment, then is often very important for the parties to decide what the case is worth. In addition, pay attention to the proof of the facts, your ability to deliver the facts and how you're going to deliver it. Good negotiators will often bring in exhibits with them to show them precisely where the facts are and be ready to show what they've got going. And that's why, in some ways, there are risks, because you're putting out your case for your opponent by showing how persuasive you are about it. And it could work in the negotiation, but it also could now arm them for some strategy issues that allows them to be better prepared about how you're going to present the case. And so there's a little caginess that goes on in a typical negotiation. Again, if we recognize that 97% of cases settle before trial, whether or not they settle right now, by the time they get to the courthouse steps, cases settle. And this persuasion statement and your ability to show that you are ready to go usually tips the balance in favor of making the argument if you've got it, as opposed to holding back on it. But again, not always. Now, to provide then some sense of balance and also room for disagreement and exchange of ideas, lawyers often will put probabilities on what it is that they say are their best case scenarios, what are the most likely scenarios as to what's going to happen in front of the jury, and what are the worst case scenarios. And part of your planning should look at that. What is my best case? What's my most likely and what's my least? Sometimes what you then do is you give that as a tool in the negotiation as part of your persuasion. You say, we have tried this case before 5 different focus groups. Every time we've had a verdict in our favor. The range of verdicts has ranged from this high to this low. Most often we're getting this. 3 of the verdicts were this. 1 was this high and 1 was this low. Boy, that's a probability analysis that's related to different outcomes that can be very persuasive then in the case. Now, what if you don't have that? Then what you're doing is you're handicapping your cases, your chances of winning and losing, that are based then on your ability to persuade them that that's what the jury is likely going to do. And you want to build in some room that the other side might see things differently. And what you do is, it seems to me, as you start to think about whether or not it's very simply a probability of winning a verdict, and whether there are, from the defense's perspective, there are compound probabilities that you have to take independently, which overall decrease the probability of success. If you want to learn more about compound probabilities and the way that they impact on valuations of cases, please take a look at the reading that's handed out in the materials here for this. So back to our integrated planning model then. We've got strategy choices, style choices, information we're going to get, information we're going to block, our opening offers that set up then the possibility for exchanges. So let me just say a quick word about concessions. After you make your opening offers and you put your persuasive statements, how do you move? Well, you know, the expectation in a garden variety negotiation is you wouldn't be here if there wasn't some kind of concession that's going to go on. Couple things to note. The size of the concession signals or can signal a bottom line, so be careful. If you prepare then one concession, the length of that concession is often close to or somewhat near the midpoint between your bottom line and your opening offer. And I would urge you to worry about the signal that you send. And good experienced negotiators often concede at the beginning very small amounts to create the impression that their opening offer was already very, very close to their bottom line. So pay attention to that. In addition, when you think about concessions, think generally about exchanges. Planning for exchanges is different if you're an adversarial negotiator or if you're a problem solver. If what you do is you say, all right, we see the difference. Besides, instead of moving, what I'd like to do is to talk about the overall goals that we're trying to meet in the position that we take. And what creative solutions then might potentially be generated between your position and our position. What we have is a concern about whether or not your damages are really going to be as great as you say they are. On the other hand, what we have is we have a concern that you're not going to be covered in your damages eventually for all the damages that are still unfolding in the case. All right, well, so this is why you value it this way, this is why you value it this way. What is then the underlying problem that we potentially could brainstorm? Is it a structured settlement of some sort? Is there a way to take the risk and put it someplace where it can be shared? Is there a way that we can pay a little bit more of a premium for the risk that's actually behind the position one of the parties are taking? So your exchange phase can prepare to respond to the offers by going into problem solving and examining the underlying needs and goals that are involved. If you're a classic position bargainer, though, you might very carefully map out what exchanges you're going to make in order to be able to figure out what the other side is willing to do. And that would be a series of moves that are positions that are not necessarily justified in terms of underlying goals and needs. If you do then make concessions, we start at $1 million and we go to $750,000, then we're going to go to $500,000. And here are the persuasion statements that we're going to make. You've got to be careful that the persuasion statements are consistent and don't contain within them concessions about earlier things that you've said that signal a much greater move or a bottom line that is not supported by what you're doing. So you might map out the positions that you're going to take, paying attention to the reasons you're given, and ask yourself, are there any vulnerabilities that are created by this style? Right? Now, if you're a position bargainer, you're searching for settlement zones. You're looking for places of overlap. If you're a problem solver, you're looking for ways to be creative to try to get win-win solutions out of the different needs of the parties. And you plan differently depending upon the type of negotiator that you are. So I always like to do is to identify the needs of the client and the opponent, classify them, essential, important, desirable if I'm a problem solver, and also classify them according to whether they're shared, independent, or in conflict. And if I'm going to be a problem solver, that will help me be more creative as I'm looking for exchanges and ideas of exchanges. So what we have then is strategy, style, get, block, opening offer, concessions. And then what happens if we hit deadlock? Again, here is an opportunity for you to engage in creative problem solving. That you plan, if there is a deadlock, to say, all right, well, I don't have any authority, you don't have any authority. Can we still brainstorm together as to what we might do to take back to our clients? For you to take back, for me to take back, in order to be able to not take this personally, but try to explore still whether there are any win-win solutions that are potentially on the table. And I would urge you as you're planning to say, what am I going to do when they walk out of the room or threaten to walk out of the room? Do I want to offer to go into a problem-solving mode at that point? And that's a way to integrate then from a position bargaining approach to this case into a much more problem-solving and creative way of dealing with it. Plan for wrap-up, restating what the parties have agreed to. Often deals break down in the restatement of what it is that we've agreed to. This is very important if there are areas of agreement and not and areas left open. You want to then wrap up what you have agreed to at this point so that you can return to them and potentially even write it up right there and have them sign it so that you've got some record of what's going on. And the write-up piece, who controls it? Obviously, be careful of that, whether it's a deal or transaction or whether it's a settlement agreement. You want to go back over that settlement agreement with care to see whether new terms have been inserted or whether or not some things have been changed in the write-up. And that's part of what you're planning for as you're planning in an integrative problem-solving or position bargaining model for negotiation. If you plan, then, with those steps in mind, you should be well in control for both the information, the exchange phase, and the persuasion phase. And in that way, you control the information you're getting and the information you're giving with the client's goals in mind, looking for ways to bring about a good settlement for both parties. Thank you.